10 seconds, 5 seconds. Start. We are therefore of the opinion that the reference made by the central government is wholly uncalled for and deserves to be set aside. Learned counsel for the second respondent has submitted that this court should not interfere with the order of the central government making a reference under section 10 of the Act, as the appellant can ventilate its grievances before the industrial tribunal. According to him, the writ petition is premature as the appellant can show before the tribunal that the reference is either bad in law or is uncalled for. We are unable to accept the submission made. This is not a case where the infirmity in the reference can be shown only after evidence has been adduced. In view of the discussions made above, it is manifestly clear that there is no industrial dispute in existence, nor there is any apprehended dispute between the appellant bank and the federation, and as such there is absolutely no occasion for making any reference for adjudication by the industrial tribunal. The reference being wholly futile, the same deserves to be quashed. The appeal is accordingly allowed with cost. The judgments and orders of the learned single judge and that of the division bench of the High Court are set aside, and the reference made by the central government to the industrial tribunal is quashed. From this fact alone, animus conduct which proves desertion on her part in the facts and circumstances of the case, it cannot be said that this desertion was with a reasonable cause. Such a conduct indicates total abandonment of marriage. It also amounts to willful neglect of the husband by the wife. Therefore, the conclusion reached by the High Court appears to be absolutely correct. This appeal is accordingly dismissed with no order as to cost. Challenge in this appeal is to the judgment rendered by a division bench of the Orissa High Court, holding that the policy decision taken by the state in the matter of allotment of quarters on rotation basis was illegal. Adumbrated in brief the factual background as projected by the appellants is as follows. An executive order was passed by the Deputy Inspector General of Police in furtherance to a policy decision that quarters were to be allotted to all the Orissa state armed police personnel for a minimum period of 3 years. This order was passed keeping in view the dearth of family accommodation. It was also done with a view to ensure that every police personnel enjoyed the facility of rent-free accommodation. The practice had continued uninterruptedly for a long time. The system was developed to ensure that the employees are provided with quarters for a given period, and after completion of that period they are required to vacate the quarters.